Good afternoon. Our next case is Sturdivant versus NC Department of Public Safety, and we will hear from the appellant.
Mr. Chief Justice and Associate Justices, good morning. May it please the Court. My name is Lindsay Smith. I'm with the North Carolina Attorney General's Office, and I represent the Department of Public Safety in this appeal. I'd like to reserve 5 minutes of my time for rebuttal. In 2011, the General Assembly passed a bill entitled Putting North Carolina Back to Work by reforming the Workers' Compensation Act. This comprehensive reform did two things that are relevant to the questions before this court today. First, it imposed a 500-week cap on the receipt of temporary total disability benefits under the Act. And second, it created a new type of benefit called extended compensation, for which employees may apply after the expiration of their temporary total disability benefits. Your Honors, there are two issues before this court today, and the first issue is about the proper interpretation of the extended compensation provisions of the Act, specifically the standard by which an employee can prove entitlement to extended compensation benefits. Now, below, the Court of Appeal applied the same standard for determining an employee's entitlement to temporary disability benefits to the separate determination of whether that same employee may be entitled to extended compensation. But this interpretation of the extended compensation provision runs contrary not only to the original 2011 enactment of that provision, but also, and I think most importantly here, to the 2023 clarification that was issued by the General Assembly in direct response to the Court of Appeals decision below. That 2023 clarification makes clear that the standard for proving extended compensation claims is different than the standard for proving temporary total disability claims. Those amendments apply here, and they conclusively resolve this issue. Now, the second issue before this court is Mr. Sturdivant's primary argument that remand to the Industrial Commission was required, either for additional fact-finding or to permit the Commission to clarify the standard it applied in light of the 2023 amendment to the statute. As we explain in our briefs, and as I'll get into more here, remand was and is simply unnecessary in this case. I'd like to start by looking at our primary argument today, whether the Court of Appeals articulated the incorrect standard when it analyzed Mr. Sturdivant's claim for extended compensation. And to do that, I think the best way is to look at the language of the Workers' Compensation Act itself, and in particular, the two types of benefits that are at issue here. Now, first, in 2011, the General Assembly imposed a 500-week cap on the receipt of those temporary total disability benefits. Now, under the Act, an employee has a disability and may prove a disability if they can show that they suffered an injury while they were at work, and that as a result of that injury, they are unable to earn the wages that they were receiving at the time of injury in the same or other employment. Now, this standard is notably different from the standard for extended compensation that the General Assembly articulated when it created that provision of the statute in 2011. And there, the General Assembly says that in order to prove entitlement to extended compensation, an employee must prove by a preponderance of the evidence that the employee sustained a total loss of wage earning capacity. So these are two notably different standards. On the one hand, an employee must show that they can't earn the wages that they earned in the same or similar employment. And on the other hand, in the extended compensation world, an employee must show that they have suffered a total loss of wage earning capacity. Now, the real question here, right, is what does total loss of wage earning capacity mean? And that's, of course, what the lower tribunals grappled with, as well as the Court of Appeals. Now, what the Court of Appeals determined or decided was that the standard for the total loss of wage earning capacity is synonymous with total disability. And that's at the pages 6 and 7 of the slip opinion, the Court of Appeals slip opinion in this case. And when it decided this, the Court of Appeals imported a standard that this court and other courts have frequently used for determining an employee's entitlement to temporary disability benefits. Specifically, that even if the employee has the ability to perform some type of work, he may still be entitled to disability benefits, or in this case, extended compensation benefits, if he shows that he cannot find a job compatible with his limited capability, or that it would be futile for him to try. Now, in other words, for the Court of Appeals and for Mr. Sturdivant, the extended compensation analysis must incorporate considerations of an employee's attempt to find an actual job, or as Mr. Sturdivant has put it, an employee's ability to get an employer to hire him. Now, the General Assembly disagreed with the Court of Appeals' interpretation of that standard. And so in 2023, after the Court of Appeals issued its decision, the General Assembly enacted an amendment to the extended compensation provision. And it did so expressly to clarify that an employee has a different standard for establishing the burden of proof for extended compensation. And that that it had issued this clarification to reflect the intent of the General Assembly when it enacted that provision. Now, what this amendment or this clarification did, it did really three things. The first, it defined total loss of wage earning capacity as the complete, and I'm quoting here from the 2023 amendments, and you can find those at page 15 of the appendix to our brief. It defined total loss of wage earning capacity as, quote, the complete elimination of the capacity to earn any wages. In addition, the General Assembly specifically rejected the application of definitions of disability as well as suitable employment to the consideration of whether an employee has met the standard for extended compensation benefits. And so although the General Assembly did allow for considerations related to an employee's individual capacity, such as the employee's pre-existing physical or mental limitations, their education, any vocational training or other experience, the General Assembly expressly excluded from consideration any consideration of external factors like an employee's search for or ability to find a job. Or, as again, in contrast to what Mr. Sturdivant is arguing, an employer's willingness to hire an employee in a particular job. In other words—
Excuse me, I would like to explore that just a little bit, the interplay between what you just said and what the statute says, that the commission may consider pre-existing and injury-related physical and mental illness, and particularly vocational skills, education, experience in determining whether the employee has sustained this total loss. How can we reconcile where that is? Because they, at least on its face, appear to be inconsistent. How can we make that all work together?
So I think what Your Honor is getting at is the distinction between factors that go to an employee's capacity, an individual employee's internal and individual capacity, versus external considerations related to an employer's willingness to hire that employee, or whether that employee has searched for a job. And I think that is the critical distinction here, Your Honor. right, is that the General Assembly made a policy determination to exclude from consideration those external factors. Now, I think that we can see support for this in a couple of different ways. The first is the Russell factors, right, and we've discussed those in our brief. Now, the Russell case from the Court of Appeals, which has also been referenced by this court in regards to determining disability claims, that case and other courts have at times incorporated these, I think what Mr. Sturdivant calls these hireability factors, right? Whether an employee is willing to hire, an employer is willing to hire an employee, whether an employee has searched for a job, as well as these individualized capacity factors.
But is it not true that whether someone would be willing to hire, it would certainly depend on the vocational skills, experience, and those kinds of things? And so that intersection is what I'm grappling with right now.
Sure, and I think you're right, Your Honor, is an employer's willingness to hire would at times depend on that. But I think I think there's a difference between whether it's necessary or sufficient, right, Your Honor? And I think that we can have a consideration of those individual capacity factors without going across the line and looking at whether those individual capacity factors would relate to the ability to find a specific job by a specific employer in the job market. I'd also like to point to the definition of suitable disability in the statute. Now, unfortunately, I apologize, we did not include it to the appendix to our brief, but it's at General Statute 97-2, which is the section of the Workers' Compensation Act that sets out the definitions. And so in addition to excluding the definition of disability from consideration, the General Assembly also excluded the definition of suitable employment. And if you look at that definition, it defines suitable employment as employment that the employee is capable of performing considering the employee's pre-existing and injury-related physical and mental limitations, vocational skills, education, and experience, and is located within a 50-mile radius of the employee's residence at the time of injury. Now, what you can see there is that the language that the General Assembly included as factors in the 2023 amendment reflects or mirrors this language up until the point where we have the consideration of the geographic location. That language about the geographic location is notably not included in the 2023 amendments. And I think that's just another a piece of the puzzle here, Your Honors, as to what the General Assembly is doing here when it is specifically not talking about these external factors that are related to, I guess, the labor market or the job market. What the General Assembly is doing is they are articulating a standard that is different from the standard for temporary disability claims. And I think we also have to go back to the overall purpose of the 2011 enactments themselves. Again, this is a comprehensive reform of the Workers' Compensation Act in which the General Assembly is placing a cap on an employee's receipt of these temporary disability benefits. And I think that if we were to accept, or this court were to accept Mr. Sturdivant's argument that the standard for determining whether an employee has met the criteria for extended compensation is essentially the same as the standard for determining whether an employee has met the standard for disability benefits, then it would render the extended compensation provisions of that statute superfluous. There would really be no reason to have this separate and additional level of benefits. I mean, essentially what the
Well, I think your friend's going to argue it does do something. It's not completely meaningless because after 500 weeks, the injured worker is going to have to come back to court and prove again, I get to keep getting my benefits. The standard is exactly the same, but it's almost like a trigger that makes you come back to court one more time.
Yeah, I have two responses to that, Your Honor. I think the first is it seems to me, unlikely or unreasonable that the General Assembly would simply have a procedural mechanism here to articulate the exact same standard, right? We're going to establish this whole new set of benefits, right, that you have to come back and prove up, but you really just have to do the same thing. You just have to come back and prove it. That just seems to me to be inconsistent with the purpose of the 2011 reforms as a whole. I think the second and maybe even more compelling reason, Your Honor, is that if you look at the 2023 clarification, the General Assembly says specifically not just that the burden is different, but that the standard is different. And I think that, to me, is very indicative of what the General Assembly is doing in clarifying that this is not just a different burden. You have to come back and reprove up your entitlement to benefits. I think it's, no, this isn't actually a different standard that we're looking at altogether, Your Honor.
Which you can see in the title of the bill, right? Because if it's putting people to work, you'd say, well, what's the purpose of that? And the idea would be you drove a truck, you made $100,000 a year, you blew out your back. Even after 10 years, you didn't get better, you're never going to be able to drive a truck again, but you can be a greeter at Walmart. The General Assembly said, this is not a social safety net, get the lower paying job. And because we need to compete with other states where that's the law. That seems to me to be one reasonable interpretation of what the purpose here was.
And I would agree with that completely, Your Honor. And I think you see that some of that legislative history is detailed in the amicus briefing, and it goes exactly to that. That is one of the purposes of the original 2011 reforms. And I think, to the extent that there is an argument that, well, if you have somebody like a Mr. Sturdivant who says, hey, I'm not able to work in this, sort of full-time capacity, and it's not fair that I shouldn't continue to get my benefits. I mean, I would respectfully submit that those considerations of fairness are a policy determination, right? That was made by the General Assembly. It had to sit down and do some line drawing around when and how these benefits would eventually expire. And so that it did that in imposing this 500-week cap. Now, of course, it did so through a compromise, and part of that compromise was allowing for this additional, these additional extended benefits, but the employees who are seeking those additional benefits really need to come in and prove a higher standard. Not simply that, as the Court of Appeals articulated, that they are able to do some work, but they haven't been able to find a job, but that they have suffered a total loss, that they are not able to do any work at all based on some of these individualized considerations. I'd also like to turn very briefly, with some of my remaining time, to the second issue that is in this appeal, and that is Mr. Sturdivant's primary argument, that this case should be remanded to the Industrial Commission. And he really articulates two reasons for this argument. The first, it is dependent upon this court's accepting his argument that the Court of Appeals was correct in the standard that it articulated. And under this argument, if the Court of Appeals articulated a different standard than the Industrial Commission, then the Court of Appeals was required to send this case back for additional fact-finding under that standard. And Your Honors, we would simply submit that remand is unnecessary here, and the Court of Appeals considered that as well, whether remand was required. And what the Court of Appeals held is, in some cases, and in many cases, the court will send the case back for fact-finding, but only where the lower tribunal has not made findings of fact that are sufficient to support a decision under the new legal standard. And that's exactly what the Court of Appeals determined here, that the Industrial Commission, even though it articulated a different standard than the Court of Appeals, had issued fairly broad findings of facts that would support the Court of Appeals' decision that included these higher ability considerations. And some of those findings of fact include that Mr. Sturdivant could perform some work, that there were some employers who could accommodate Mr. Sturdivant's limitations, that Mr. Sturdivant's experience, education, and physical limitations were such that it would not be futile for him to obtain work, And the Court of Appeals also considered that there was no evidence that Mr. Sturdivant had sought for or been unable to find a job. And so because of this, the Industrial Commission's broad findings of fact were sufficient for the Court of Appeals to go ahead and issue a ruling based on the standard that it articulated. Now, of course, as I said before, that's really dependent upon this court accepting that the Court of Appeals standard was correct, which we disagree with. If the court agrees with the Department of Public Safety that the Court of Appeals articulated the incorrect standard, then there is still no need for remand here. And the reason for that is that the Industrial Commission, in issuing its findings and its conclusion, applied the very standard that the General Assembly articulated in the 2023 amendments. And because of that, sending this case back to remand under either standard is unnecessary and redundant, Your Honors. Your Honors, if there are no further questions, I will save the remainder of my time for rebuttal.
Thank you, counsel. Hear from the appellee.
May it please the court, Chief Justice Newby, Associate Justices, my name is Stuart Poisson. I'm here today with my father, Fred Poisson Jr., on behalf of our client, Martin Sturdivant. My father and I have represented Mr. Sturdivant for over 18 years. If Mr. Sturdivant prevails here today, he will obtain a remand to the Industrial Commission, where he will win the chance to get his right to get an additional $40 a week in benefits. That is what is at stake here for Mr. Sturdivant. My colleague did not mention some of the very important changes to the Workers' Comp Act that took place with the 2011 amendments. One of those changes was to give employers a credit for retirement benefits. And Mr. Sturdivant is now 68 years old. And so he is not looking for a social safety net here. He is looking for the benefits to which the legislature says he's entitled. When the legislature used the words total loss of wage earning capacity, it meant total loss of wage earning capacity. It did not mean total loss of the ability to work. First, I'd like to talk to the court a bit about my client, Mr. Sturdivant, so you understand who he is and his background. And then I'm going to turn to the law and why we are correct in our contention as to what total loss of wage earning capacity means. Mr. Sturdivant is from Anson County, and he is someone who has worked his entire adult life. As the full commission found, he's worked as a poultry farmer, he's worked as a drywall laborer, he's worked as a logger, he's worked as a machinist, and he's worked in manufacturing, and finally maximum security prison guard. This is somebody who, in the time prior to his injury at age 51, his first injury, who had worked in many different difficult, hard, and even dangerous vocations. He is someone who is not afraid of work. In 2006, he suffered a back injury while he was working in manufacturing, and he continued working for another 5 years after that injury. He is not someone who wants to be out of work. He is not someone who wants to be receiving workers' compensation benefits. After he moved on from that job, he moved to the state of North Carolina as his employer, and he worked in a maximum security prison, protecting the public with some of the most dangerous inmates that we have at Lanesboro Correctional Institute. And that is where he was injured in 2011, and he attempted to go back to work but was unable to do so. And so at that time, the state denied him benefits. He went to the commission for the first time and fought for the compensation to which he was entitled. Not because he wanted to be on workers' compensation, but because he had to be. After that, after he prevailed in his case, he asked the state to please take him back to work. He said, please accommodate me. The state is the biggest employer in North Carolina, and even it said, we cannot accommodate you, or we will not accommodate you. It terminated him, and it did not provide any vocational assistance to him whatsoever in his quest to obtain employment. And so what did he do? He went on his own, did the best that he could. He applied for jobs. He asked around to other friends to see what might be available, but he couldn't find anything. So he applied for Social Security disability compensation, and he was awarded those benefits because under the federal standard, he was deemed entitled to those. And so time went on. Mr. Sturdivant continued to draw his benefits. He continued to get medical treatment. The state had him assessed for vocational rehabilitation services. They were recommended, and the state did not provide them. And then Mr. Sturdivant comes to the Industrial Commission again for a second time in 2020, and he asks that the commission find that he qualified for a total loss of wage earning capacity, extended compensation, and he's rejected. He appeals to the full commission, and he asks again, and he's rejected at that stage too. And they find that at that point, he's relegated to part-time sedentary employment. This is work that he's never been hired to perform in his life. He has no experience in that area whatsoever. He has no idea how to even begin to obtain a job in part-time sedentary work. He then goes on to the Court of Appeals. He asks the Court of Appeals to give him some relief. They reject his plea. And here he is at the Supreme Court on the Attorney General's petition for discretionary review, asking for some relief. And it is his hope that given that this court has taken this case up for review, that it has some relief to give him. And that relief is a remand to the full commission for redetermination. There are two reasons why this should happen in this case, and this was the issue that we raised in our response to PDR. Number one, the Court of Appeals majority got it wrong, the dissent got it right. If they felt that the standard was incorrect that the full commission used, they should have remanded the case down to the Industrial Commission for redetermination under the appropriate standard. And second, and most importantly, in direct response to the Court of Appeals opinion in this case, the legislature intervened and acted and said in the footnote to its budgetary amendment that it was directly addressing the Court of Appeals opinion in this case to clarify that there is a different standard under 9729C than there is under 9729B. And I want to stop and talk about a comment that my colleague made indicating that Mr. Sturdivant has contended that it's the same standard. I urge the court to go back and look at my brief to the full commission, which is contained in the record on appeal. Mr. Sturdivant nor his counsel have ever argued that this is the same standard. Very clearly, 9729B benefits for temporary total disability are tied to the same or similar wage and are protected by suitable employment, 97222, which my colleague referenced. When we talk about a total loss of wage earning capacity under 9729C, we are talking about a total loss of wage earning capacity. It doesn't matter what the job is. It just has to be a real job in the general labor market. It can be full-time, it can be part-time, it can be temporary, it can be seasonal, it can be a different wage.
Does the Court of Appeals opinion state that position, or did they say something else?
Your Honor, the Court of Appeals opinion is not written as well as it could have been, and I'll be candid about that, and I believe that's why the legislature intervened. They indicated in that opinion that it's the same standard, and if you read that for what it means, then I would say that it implies at least that it's tied to the same or similar wages. And I believe that that's why the legislature acted here. But if you look at what we argued at the full commission and all along, Mr. Sturdivant has never argued that. We have always contended that our burden is to show that he has a total loss of wage earning capacity in any employment. And that, again, part-time, temporary, full-time, seasonal, same wage, different wage. So as Your Honor mentioned earlier, this is a motivator for the injured worker to attempt to find this work and to go out and get these jobs if they can, because it is a clear indication from the legislature, we don't want you to just continue receiving temporary total disability for the rest of your life. If there is a job out there that will hire you and will have you and pay you a wage, you need to go get it. And that is what I've always contended the standard is. And so it is frustrating to me today to have counsel, my colleague, indicate that we have contended it's the same standard, because I have not. I never have. What we are looking at here is the ability for these injured workers to compete in the general labor market to get a job. People like Mr. Sturdivant, who have done the best they can with their lives, who've worked in hard jobs, undoubtedly hard jobs, who have always worked and earned wages, but who now find that the majority of jobs in the vocational sector are eliminated for them because of their injury. And so now they're relegated to a very small portion of the jobs that are available in the general labor market. For Mr. Sturdivant, part-time sedentary work. And so here he is competing against other candidates for these jobs, a very reduced number of jobs, and he's at a disadvantage. And my colleague, the Attorney General's office, would ask that this court find that there is no competitive marketplace component to any of this analysis.
So, yeah, can I restate your position just so I make sure I understand it? So, in your view, wage earning capacity is not just your physical ability in an ideal world where any job you're qualified for you would get to do the job. Your position is things like the state of the economy that mean how many jobs will be available are part of that capacity. If there just are no jobs available, then you have suffered a total loss of wage earning capacity. And your position is you have to consider those realities, not just the state of the injured worker. Is that what you're arguing?
That is correct, Your Honor. That's exactly what I'm arguing. I have written here ability to work, ability to get a job. And that can be influenced by the number of jobs that are available because of market conditions. It can also be influenced by the number of candidates who are vying for a particular job. Part-time sedentary jobs are a very small subset of the available jobs out there. And the Attorney General's office would have this court hold that the legislature intended for these injured workers to be assessed in a vacuum, that just on paper, Martin Sturdivant has part-time sedentary capacity, and therefore this matches up, and so we think he can get a part-time sedentary job. We're not going to look at the fact that he has to compete with anybody else for these jobs. We're not going to look at the fact that he has no experience in this type of work. We're not going to look at any of these factors. We're just going to say that that ends the inquiry.
So, yeah, your friend didn't really make this argument because I think he was focused on something else. But you know, one pushback on your interpretation here is that choosing the word capacity, so capable, is a word that you typically use when you're looking at, you know, some person, like here it would be the employee, and that you would think if the General Assembly wanted to incorporate both the capability, the capacity of the worker to earn the wages, and then also outside factors that are beyond the control of the employee, you might have worded it somewhere else, that any wage earning capacity or availability or some sequence of words that said we want to encompass everything and not just in a theoretical world, are you capable of going out and earning a wage somewhere? Because that would, you know, the putting you back to work part would be if you are, then go out and try to find the job. So what is it about capacity that you think includes, you know, things outside the employee's control, the state of the economy and all that sort of thing?
Well, Your Honor, I think it's a great question. Capacity means ability, essentially, the ability. So the ability to earn wages. What are the ingredients that go into earning wages? One is the ability to work, so you have to be physically and mentally able to work, and the other is the ability to get a job. I can go work all day long at my house, and nobody's going to pay me to do that. The fact that the legislature used the term wage earning ties it to the ability to get a job. And if you can't get a job, you can't earn wages. And so that is why I believe that the use of the term capacity encompasses not only physical and mental capacity, but also capacity to get a job. I also thought that it was—
So second part of that,
Sure.
I'm sorry to interrupt you, but, and then I think your friend also, if was addressing this, would then say, well, let me take you one step back in the language. It's just, it's a loss of the wage earning capacity. And again, fluctuations in the economy you wouldn't think of as losing that capacity in the way that you would think of, I had an injury, now I can't work at all, I've improved a little bit, now I can get some job, and so I don't have a total loss, I just have a partial loss of my wage earning capacity. That seems more natural than to say whether or not you've suffered a total loss of wage earning capacity will depend on whether we have a recession when you hit 500 weeks or not.
And Your Honor, I'm not as concerned about the marketplace factors as I am about the competitive factors. I mean, the capacity to compete with others to get a job, the capacity to get someone to hire you, whether in a boom or a bust economy, the injured worker is always competing with someone else to get a job. And so if they don't have the capacity to participate in that economy to get a job, then it doesn't matter if they can work or not. Some injured workers have different factors, such as facial disfigurement and other things that make it easier for them to get certain kinds of jobs. And then if they get an injury or have an injury on the job that keeps them out of those types of jobs, they then have to go compete with other people for jobs that they never even contemplated being able to get. And so if they are unable to compete with those other people, they don't have the capacity to earn wages. And I look at the fact that the legislature intervened in this case, which I think the court would acknowledge is rather extraordinary, and the legislature specifically referenced this case, and it added these factors that it indicated that the Industrial Commission may consider, and it did it in direct response to the opinion here. And when we look at what the legislature did, they said, first and foremost, it's a different standard. And they wanted to make that clear. That was something that was confusing in the Court of Appeals opinion, which frankly at one point said it's a different standard and at one point said it's the same standard. Then it said disability doesn't apply, suitable employment doesn't apply. That clarifies some things. And then finally it said here are the factors the commission may consider. And what are those factors that the legislature enunciated? Those are the exact factors that this court has looked to for decades in assessing the ability to earn wages. And so those factors, as Justice Barringer indicated, go to an employee's ability to compete in the general labor market to get a job, vocational skills, education, work experience, pre-existing mental and physical limitations, and then of course the injury-related limitations. Those are market factors. And so my colleagues' comment that external factors don't play into anything here is contrary to what the legislature did when it amended the statute in 2023.
But I'm sorry, but as I read these factors, they all seem to relate to the employee, his pre-existing and injury-related physical and mental limitations, his vocational skills, his education, his experience. So I'm not seeing where because as I understand your argument, you're saying you do agree that this applies to this case, but you believe it supports your client's position. And what I'm not seeing in here, though, is anything that says, and relevant labor market or availability of suitable jobs.
Thank you, Your Honor, for the question. Again, I'm not as concerned about the prevailing market conditions, whether there is a boom or bust economy. It is the ability to compete with other people in that same labor market, whether it's robust or not, for the jobs that are available.
So then let me ask you this. Are you saying that this needs to be remanded because the Industrial Commission did not consider these factors?
I don't believe that they did consider these factors in this context. And if you read the opinion and award of the full commission, as I indicated in my brief, it did not specifically state what it understood the standard to be. It said unable to earn wages in any employment, but it did not, or lack of wage earning capacity. It used those phrases, but it didn't say what it understood that to mean. And it went on and concluded that Mr. Sturdivant retains wage earning capacity on the days when his pain is not 10 of 10 pain, which it found to occur at least once a week. That does not look at a real world standard of ability to get a job, ability to compete with others to obtain even part-time sedentary employment. Even a part-time sedentary job expects you to show up when you're scheduled to show up. And if he has 10 of 10 pain once per week, which is what the full commission found, and that happens on a Wednesday and he's scheduled to work on Wednesdays, and then it happens on another Wednesday, well, he's missed multiple days of work for a part-time employment. And all employers have to rely on their employees to be able to show up and work, even part-time employees. And so we very much contend that the full commission erred when it applied the standard that it applied. And also, more importantly, I have no doubt that the Industrial Commission did the very best that it could to try and understand the parties' arguments and read the legislation and interpret what total loss of wage earning capacity means. But at the same time, the legislature has now acted. The state has argued that it very much clarified a statute that was confusing before. And so why should the Industrial Commission not get the benefit of that clarified standard when it's determining my client's case? My client is here.
So can I, and again, I'm sorry to keep interrupting,
Sure.
but just so that I understand your position. So are you saying essentially you don't agree with the Court of Appeals position that total disability in B, total loss of wage earning capacity in C are just synonyms? And in your view, the legislative amendment was just identifying what the statute has always meant all along, but usefully provided those factors in that second sentence that you think the Industrial Commission didn't quite contemplate in the order. So your position would be essentially, if we say the clarification wasn't even needed, this is what it always meant, and the Court of Appeals was wrong, that we do need to remand it because we have to apply the law as it exists, which is this. The Industrial Commission didn't look at these factors in that second sentence of the clarification, so we need to send it back to them and let them reconsider it. Is that essentially what you're arguing?
That's correct, Your Honor. I mean, certainly, the Industrial Commission did not have the benefit of an explicit statement from the legislature saying you may consider these factors. And
But were we to do what you're suggesting, we would also be holding that what's in the clarifying amendment has always been the law, essentially. That was also in the original.
well, and Your Honor, as you'll recall, I opposed the petition for discretionary review in this case. So I did not take the position that this was a clarifying statute or that it was an amending statute. But once the court received this case and invited me up here, I have to assume that the state's position that is a clarifying amendment is something that this court is willing to entertain. I have not taken the contrary position. I can't imagine that the court would have accepted this case for review if it didn't feel that there was something that it could do for my client, such as give him a remand. And as far as the Court of Appeals standard that it articulated and how that compares to what the legislature did, I think there is common ground there. And I think very much when the Court of Appeals said, we're looking not just at people who are unable to work, but also people who are unable to get jobs, that is very consistent with what the legislature said. The part that I believe the legislature wanted to clarify is that this is not the same exact standard as it is for disability. And if you look at the hierarchy between 9729B, which is temporary total disability, C, which is total loss of wage earning capacity, the benefits we're talking about today, and then D, which is total permanent disability, I think it's very helpful for this court to go back and look at that statute and look at the language. Because as we've already discussed, the temporary total disability benefits are tied to the inability to earn the same or similar wages. They have the protection of suitable employment. It's a more generous standard to the injured worker. Then you move up to the next level, which is C, and that's a newly created subsection of folks starting in 2011. And in C, we have total loss of wage earning capacity. That means in any employment. It means either you're physically and mentally incapable of work, or you are unable to get somebody to hire you in any employment. You don't get the protection of suitable employment anymore, and you don't get the protection of same or similar wages. Then we move on to D, and this is really the worst of the worst. These are the injuries that you don't want to have. These are people who are quadriplegic, paraplegic, who've lost both hands, both arms, both feet, or both legs, who've been burned over more than a third of their body. And these people are presumptively entitled to these benefits if you can show that they meet these categories. The language that the legislature used in subsection D is that somebody who has lost both hands, both legs, both feet, both arms, any of those those pairs may receive these benefits regardless of whether they return to work in any capacity. And the legislature specifically used that phrase in D, work in any capacity. And so if it wanted to use the phrase total loss of the ability to work in any capacity, it could have said that in C. It certainly used that language in D, and it enacted C and D at the exact same time, both in 2011. And so the fact that the legislature used that phrase that the state is advocating for in one portion of this statute, but didn't use it in the portion that we're talking about here today is very important. So if you look at the different considerations we have with statutory interpretation, looking at the plain language of the words, looking at the technical meaning, if there is a technical meaning that has been adopted, and then if you look at words that the legislature used elsewhere in the statute, they all match up here. They all equate to not only looking at the physical and mental capacity to work, but also looking at the capacity to compete in the general labor market to get somebody to hire you. And so we contend that this court really needs to consider what the legislature did and did not say when it used the standard that it used in 9729C. And realistically, there are going to be injured workers like Martin Sturdivant who have been out of work for 10 years because of their injury when they come to the court seeking 9729C extended compensation. Some of these injured workers will have had the benefit of vocational assistance. That's an expert who is hired to help these injured workers attempt to find a job. And so what is this court going to say about an injured worker who has been in vocational rehabilitation with an expert for, let's say, 7 years and still is unable to find anybody to hire him or her? Are we going to say that the legislature intended for that person's benefits to stop at the end of 500 weeks? I don't believe that's what the legislature intended. If it intended to say return to work in any capacity and wanted that consideration to occur in a vacuum without looking at the other candidates out there for these jobs, it would have said so, but it did not say so. So we asked the court to please interpret the legislation as it was written. We asked the court to please look at what the legislature did when it amended the law in 2023, and we asked the court to affect the intent that the legislature had when it wrote this statute and not to adopt the draconian interpretation that the state has advocated, which is physical and mental incapacity to perform any work. That would be contrary to what this court has held in decades, that it's assessed loss of wage earning capacity. I have a few more comments that I'd like to make, and then I will close unless the court has any more questions. My colleague referenced the definition of suitable employment and indicated that the definition of suitable employment says that it applies to the capacity of the injured worker to perform the work. But yet, we have the legislature in the 2023 amendment saying the definition of suitable employment does not apply to extended compensation cases. So what do these factors that it listed in its amendment to 9729C pertain to if they do not pertain to the employee's capacity to perform the job? They apply to the employee's capacity to get the job. And that is consistent with what this court has always held. And as we argued in our brief, it's not just the state of North Carolina that looks at loss of wage earning capacity. It's every other state in the nation. This is a grand bargain that was struck, the workers' compensation system, between industry and the injured worker. And the purpose of this is to compel industry to take care of its own wreckage. And here we have a situation where in 2011, industry obtained a cap of 500 weeks on benefits. The legislature believed that it needed to make an exception for people who could not work or who could not get a job. And then it gave the employer something else that is so valuable. It gave this credit for retirement benefits so that when people like Mr. Sturdivant reach retirement age, the employer gets a credit for the retirement benefits that that employee has paid in over his entire working life. And so here there are going to be workers, many workers like Martin Sturdivant, who if they win their case, they're going to get less than $40 a week. And so we're not asking for the floodgates to open or for a windfall to Mr. Sturdivant or any other injured worker like him. We are simply asking for industry to take care of its own wreckage, which is what the legislature has always intended. We are asking for the employers to uphold their end of the grand bargain. And we're asking for this court to please make sure that they do that. I appreciate the court's time today. I appreciate the invitation to be here. I appreciate the invitation, in particular on behalf of Mr. Sturdivant, because it leads me to believe that this court has some relief to offer him. And after striking out 3 times, he certainly could use some relief. I appreciate the court's time today. Thank you.
Thank you. Rebuttal.
Your Honors, I'd like to address just a few points in response to my colleague's argument just now. I think first to address the distinction between, whether are we arguing for the same standard or are we arguing for a different standard? And certainly it sounds to me, as Mr. Sturdivant's lawyer has clarified, that nobody here is arguing that there is the same standard here for determining extended compensation claims as for temporary disability claims. However, what I would invite this court to do is to look at not simply what we're saying here, but what actually is happening when, at least what the Court of Appeals did when it imported these Russell factors into its analysis. It was, in effect, articulating the same standard as courts often use for determining disability claims. And that goes to the central issue at the heart of this case, right? Whether total loss of wage earning capacity involves considerations of hireability. That is, an employee's ability to find a job or get an employer to hire him. That's the central issue here.
So
And-
the state of the law right now is the clarifying amendment, which says that the Industrial Commission has to consider this list of factors. In your view, when the Industrial Commission first considered Mr. Sturdivant's case, did it consider all of those factors?
So it made, Your Honor, it made findings of fact that would have allowed it to consider, it made broad findings of fact. Now
What I'm saying is there enough in there to know that at the time the Industrial Commission did that, it understood that this is the law? Because
yes,
if we have to apply the law as it exists right now, so I'm trying to figure out, do we need to give the commission the opportunity, knowing this is the current law, to take a look at it?
yes, Your Honor. If you look at page 185 of the record, which is the last page of the Industrial Commission's order, and it's paragraph 8 on that page, which is essentially the last paragraph of the Industrial Commission's conclusion. And there, the Industrial Commission said, the full commission concludes, and I'm quoting here, that plaintiff has failed to meet his burden to establish by the preponderance of the evidence that he has experienced a total loss of wage earning capacity. He has satisfied the time prerequisites. However, and this goes directly to your question, Justice Dietz, considering all the circumstances related to plaintiff's wage earning capacity, the full commission notes, 1, that plaintiff is not medically restricted from all work. 2, plaintiff is a high school graduate with some community college experience. This goes to plaintiff's education. Plaintiff has some transferable skills. This goes to his vocational training and his experience. And there are sedentary positions within plaintiff self-reported restrictions in nearby counties. And so, again, I'm not going to read the entirety of the paragraph, but I think, Justice Dietz, that's exactly where the Industrial Commission is looking at some of those individualized factors that the General Assembly articulated in its 2023 amendments. And so, for that reason, we would say there is no need. It would be redundant to remand this case to the Industrial Commission because the Industrial Commission already incorporated some of those individualized considerations, Your Honor. And I think, just to kind of hit on a couple of other points, I think, Justice Dietz, you also hit very clearly, I think, on this distinction that we have been trying to make between the capacity, the individual's capacity, and these sort of external factors. And that's exactly what we are saying here, right, is that these considerations go to the individual's individual internal capacity to work as opposed to these external considerations. What we are not doing, Your Honor, is we are not suggesting that Mr. Sturdivant is afraid of work, nor are we suggesting that Mr. Sturdivant is somebody who doesn't want to work. I think the question here is really under the policy decision made by the General Assembly to cap temporary total disability benefits at 500 weeks and provide I would say, narrower avenue for extended compensation benefits, whether Mr. Sturdivant carried his burden to prove his entitlement to those benefits.
So I'm having a little bit of trouble, and maybe you can help me. If we say that what the General Assembly meant was a total loss of the ability to earn wages in any employment, why would we look at things like education? Because there are some jobs out there that require almost no education. So, and I think you could make the same, or pose the same question for a number of the other factors that the clarification, that the 2023 clarification asks us or says that should be considered.
So I think, Your Honor, I think the reason that the General Assembly is asking us to look at those individualized considerations is to really make an individualized assessment of where that employee is. And I take Your Honor's point that there are some jobs that don't require a certain amount of education, though they wouldn't necessarily require, for example, a college degree. But I think it is important, though, in determining whether an employee has the capacity to work to at least have some sort of understanding of what this employee's individualized capacity is.
But
And
you could also say the same, just to continue the point, with respect to vocational skills. I mean, certainly there are some jobs out there that don't require skilled workers. And so I'm just struggling to fit all this together.
Yeah, and I mean, I think I would go back to my earlier point, Your Honor, that I think that it's impossible to make a determination about an employee's capacity for work without having some picture of what this employee is able to do based on.
Can I just give you a hypothetical? I've struggled with this too, but
Yes.
this is the only thing that can make sense to me. So suppose you were just a world-renowned astrophysicist, but you're injured in the workplace and you're quadriplegic. There's a lot of work you can do because companies all around the world would pay you millions of dollars for your mind, and you're still able to communicate and do that. If you have no education, if you were a middle school dropout and you're injured at work and you're quadriplegic, there just may be no way that you can do any job and get paid. And is that maybe what the legislature is trying to get at there? That the ultimate question they want you to figure out is, are you capable of earning wages somehow? And consider these things in determining that. Don't just look at what the injury was, something like that.
Yeah, I think Your Honor has put it in a much more eloquent way than I have this morning. I mean, I think that's exactly the distinction that we want to be able to make when we're looking. This is why we need to make this individualized determination, is to determine, are there, is there a world in which this particular employee could work, could do some kind of work. And I think the hypothetical that Justice Dietz proposed, I think, is exactly that type of scenario, and that's why we would want to consider those particular education or vocational skills, those types of individualized considerations. Your Honors, if the court has no further questions, we would simply ask that this court vacate the portion of the Court of Appeals opinion that carries or at least articulates the incorrect standard, and that this court confirm that the standard for extended compensation claims is different, as the General Assembly has clarified, and it does not incorporate considerations of hireability. We would also ask that otherwise this court affirm the Court of Appeals determination that Mr. Sturdivant did not meet his burden to prove extended compensation here. Thank you. I appreciate your time this morning.